thank you to everyone who has joined. I know it continues to be a difficult time in the world. COVID is surging in South Asia. We are dealing with anti-Asian violence here in the United States, gun violence, and really so many other crises. And so thank you for making the time to be here, to be present, and to join this conversation. Guantanamo has been I think, a sort of seminal human rights issue of really the last 2 decades. And it's an issue that unfortunately often goes ignored and forgotten, especially in the last few years. This panel is really meant to continue to get people to think about Guantanamo. And to do that, we have assembled a really great group of panelists. We have Alka Pradhan, who is Human Rights Counsel, Military Commission's Defense Organization at the Department of Defense in Washington, D.C. We have Andrea Prasow, who's the Deputy Washington Director of Human Rights Watch in Washington, D.C. And we also have Katherine Porterfield, a psychologist at the Bellevue Program for Survivors of Torture at the NYU School of Medicine in New York. The agenda for today is we're going to be hearing from each of the panelists. I'm going to be presenting them each with several questions. There will then be time for a brief synthesis. The panelists will then have a chance to discuss special issues, an opportunity to respond to one another, and then we'll open up to questions from the audience. With that, I want to go ahead and address my first question to Kate. And I want to actually start by saying that's intentional. I think for too long, when we think about Guantanamo and we think about the human rights crisis at the base, obviously this is sponsored by the ABA, and I think lawyers are important. But for too long, lawyers have been the only ones at the table, the only ones who have participated in the conversation. And I think it's that much more urgent that we speak to people who can address the long-term health consequences of torture, detention, and mistreatment at the base. And so with that, I will start with Kate. Kate, can you tell us a little bit about the conditions that the detainees at the base presently face, and some of the long-term health consequences of their detention and mistreatment?
Sure. So first, thanks for having me, Professor Sethi and ABA and this crew of people who are so experienced in Guantanamo and the legal issues, as well as, you know, the holistic set of things going on down there that we deal with that are not just legal. So just to start with your question about conditions and about the state of detainee mental health, just quickly, disclaimer, I guess, I'm not going to use examples drawn from any current cases or identifiable individuals, and also nothing that I talk about could be construed or should be construed as affirming or denying any classified material, anything from the protective orders from our military judges, or any other, you know, invocation of national security that requires restriction for classification purposes. So nothing I say will confirm or deny those factors. So, I mean, just to give a quick context, I've been going to Guantanamo since 2008 as a mental health professional in a variety of contexts for evaluating and working with detainees. And, you know, I've seen several camps in Guantanamo. So again, I'm not going to actually talk specifically about camp conditions. Some of that information is classified, but I can say that from, again, public sources, I've seen kind of the range of things that we hear about, and that there are some very, very difficult conditions down there that involve, you know, everything from isolation and disciplinary areas with that are very, very difficult areas, meaning there's very, very bad noise and odors and difficulty that that is being experienced in those settings. So the conditions there are, you know, there are places in which I think, as we see in public source material, are really, really hard incarceration conditions. And there's other camps that are less so. Now, for me, I think you have to kind of frame the idea of mental health impact of Guantanamo by understanding that this is a place where, the detainees there have all suffered abuse at the hands of those who are imprisoning them. So some of that abuse has been very serious, maltreatment that, has been detailed in the SSCI report, that rises to the level of what's been legally called torture. So you really can't talk about Guantanamo now if you don't think about the past, which is, torture. And so what I think is helpful to think about is like, well, what do we know about the impact of torture on people and maltreatment and isolation? Because we know a lot about it. These are not new unknown variables. We actually have international laws that have been written about this and guidelines like the Mandela rules and, going back to Geneva Conventions that were designed to make sure that people, don't get maltreated and then have to deal with the impact of that. So just quickly on what I think we know in our field as the impact of torture, we know that torture ruptures a number of the basic domains of human functionality, that torture, the effects of it, leads to extensive physical, psychological, and social consequences. And I kind of delineate them: physical, the body; psychological, thoughts, feelings, and meaning making; and then social, how we do with other people. And torture affects, everything from physical problems of musculoskeletal injuries, traumatic brain injuries, chronic sleep and arousal problems, range of physical. Torture also affects our thinking, our feelings, so leads to, post-traumatic stress disorder, depression, despair, suicidality, psychosis. These are all expectable responses to chronic abuse and maltreatment. And then social problems, so isolation, feeling unable to talk to people or trust them, withdrawal, paranoia on a more extreme end, aggression also on a more extreme end. And again, remember, we're talking about a condition of confinement where, unlike other prisons all around the world, there are no visits with outside people besides legal teams and ICRC. And there's no contact with family except very, very limited controlled contact. That's a really important social factor. So finally, and I'll pass it off, but to me, the domains that we're thinking about, the biological, the psychological, and the social, they're all affected. So all of those issues need treatment or care, right? And what we have instead is a detention center in which there is not treatment provided for those effects of torture. So specifically, there's not torture treatment, which again, we know what torture treatment is. It's a treatment in which you address the biological, the psychological, and the social. And that's not provided because the detention center does not acknowledge or take histories from detainees in which they can process and report their torture. So it becomes a really problematic setup for the health, well-being, or even a modicum of healing to happen to these men. So that's kind of my overarching frame on what the detention center is that we know of in the present time in Guantanamo, and then what the effects are that the detainees are living with. And I would say there's no real therapeutic recourse right now.
Thanks so much, Kate. I think that framing is really important, and I think that's a framing that lots of folks should use when thinking about the base, the atrocities that have been perpetrated, and what the way forward looks like. So thank you. I'd like to now go to Alka, and this is a related question in part. Alka, how would you characterize the detainees' fitness to stand trial? And what are some of the other potential legal failures of the commissions?
There's so many. I have to give the same similar disclaimer to the one that Kate gave. I'm an employee of the Department of Defense, and nothing I say ever represents the opinion of the Department of Defense, and nothing I say should be taken to confirm or deny anything that the government considers to be classified. I represent one of the 9/11 defendants, who are there are 5 being tried together in what we call the 9/11 case at Guantanamo at the military commissions. I represent Amar al-Baluchi, who is, for those of you who've seen Zero Dark 30, he is the detainee who is tortured at roughly the first 20 minutes or so of that film. Now, obviously, we're coming to 20 years of the prison's existence at Guantanamo, and we're coming up on the 18th year of Amar's arbitrary detention, detention that the United Nations Working Group on Arbitrary Detention has determined is arbitrary under international law. He's been diagnosed with a traumatic brain injury that depletes his cognitive abilities more and more each year. And I really appreciate sort of starting with Kate and framing it in terms of the medical issues down there now, because it's just the single most important thing. The United States government just absolutely refuses to give him or the other detainees the treatment that they need. And, to be honest, that kind of treatment isn't possible at Guantanamo, partially because of just the scarcity of resources. Even, regular healthcare at Guantanamo is substandard. But also because you can't rehabilitate a torture victim while they're incarcerated by the people who tortured him. 20 years on, we're really kind of beyond the academic, once perhaps possible, once practical idea of putting these men on trial. This is a full-blown, ongoing humanitarian crisis in which men are literally deteriorating. Some have died on the government's watch, while we dither about whether or not they're entitled to all the accoutrements of due process. Neither these conditions, nor the withholding of medical care, nor the illegal military commissions as they exist, would be happening. And I have to say, if they were white men from a Western country, they just wouldn't. And that leads me to some of the other, kind of fatal legal flaws of the commissions as they come to me. 9 years into a purported law of war proceeding, there's no resolution about several of the charges, which are or were clearly not war crimes on September 11th. And we have experts like David Sheffer, like Marco Sassoli, who agree that the death penalty charges of conspiracy and terrorism and hijacking are not war crimes, should not be adjudicated at the military commissions. Time and time again, the government has violated attorney-client privilege at Guantanamo, and then classifies the details so we can't talk about it publicly. So that's all I could say about that for the most part. The 9/11 case alone has had 7 turnovers in judges, 4 of them just in the past year, which means there is no judicial continuity for one of the most complex cases in US history. And that sort of brings me back, right, to, I guess, full circle to the biggest fatal flaw of the commissions, which is that they're built around torture. They incorporate torture and they sanitize torture. Again, we're 9 years into pretrial hearings, and we're still fighting the government for torture evidence from the CIA black sites, which has caused the most delay. There's a reason that this has taken 9 years in pretrial hearings, which is sort of unheard of in our regular court system. What the government calls their primary evidence against the 9/11 defendants, and I want to just drill down on this for a hot minute, because this is the center of what we're fighting about right now. What the government calls their primary evidence in the 9/11 case are alleged inculpatory statements that the detainees made to the FBI in 2007 at Guantanamo Bay shortly after they arrived from CIA black sites. And the government markets these statements as quote unquote clean team statements. These are the cleansed statements, not derived from torture, according to the government. What we didn't know until relatively recently was that the same FBI agents who questioned Amar in 2007 and got those statements had been sending those exact same questions on the exact same topics to the black sites to be asked of Amar over and over and over again, and for all of the 9/11 defendants, right, during their years of CIA torture and incommunicado detention. And what we also didn't know until relatively recently, which was initially raised by the SSCI report, is that even after the men came to Guantanamo, and when they were being questioned by the FBI, they were still under the operational control of the CIA. They're being questioned at Camp Echo 2, which is one of the former black sites at Guantanamo Bay, in which some of them had been previously held. Now, anyone with a passing familiarity with the effects of torture, and I don't claim to be nearly the expert that Dr. Porterfield is, but anyone with a passing familiarity of the effects of torture, as well as just knowledge of some of the international torture jurisprudence, will tell you that those statements, the government's main evidence here, are obviously torture tainted, right? Like, it's kind of black and white. And so we're in the middle, and this is going to have to be handled now by a new judge. We're in the middle of hearings about whether those statements are going to be thrown out. And the fact that we are here at this point, 9 years after charges were sworn, still arguing over what happened to Amar and the other defendants at the black sites, still arguing over whether or not it is acceptable for the United States to use torture-acquired evidence to convict and execute civilians on non-war crimes charges in a faux military court, sort of tells you all you need to know about the absolute wreckage of law at Guantanamo right now. And I can hear myself building into a rant, so I'll stop there and let you move forward.
Thanks so much, Alka. We'll definitely have a chance to come back to you to hear a little more about the wreckage. You know, two things I wanted to highlight. It's important to just sort of state and acknowledge, you know, as we all know, that, you know, Guantanamo is and always has been a prison for Muslim men. And as a consequence, the legal wreckage that the United States and arguably the international community is willing to tolerate is that much larger because of the identity of the detainees. I also know, just from some of my recent readings, it was a shorter window of time, but there was a period of time in the United States, I think it was Attorney General Gonzalez's first memo, or one of the first memos, where torture at one point was defined to only constitute those activities that led to organ failure. You know, that's how expansive at times the techniques were that were being used. And it's stuff like that that, you know, we're contemplating using. It's frightening, it really is. Andrea, Human Rights Watch has previously said there's a legal and political imperative to close the base. Could you talk a little bit about Human Rights Watch's efforts in this regard?
Sure. Well, it's been a long 20 years, and I would just ask people to stop and think, where were you in January 2002 when the detention camp first opened? I was in law school, and since then I've worked for a firm, worked for the government, been a human rights activist, gotten married, got divorced, got married again, had 3 kids, had a dog. Think about how much life you have lived since January 2002. Alka's clients were not there at that moment, but relatively near, were in detention not too long after. This is something that some of you listening may have lived with your entire conscious lives. Certainly the law students now, many of them did not really know of a world where there wasn't detention in Guantanamo. And that is one of the many, many reasons why we believe it's really imperative that it be closed, and that it be closed quickly. A lot of people talk about the need for Guantanamo to be closed responsibly, and I don't know what that means. Closing it responsibly would have been closing it on January 12th, the day after it opened. Responsibly means you let the people go who are not accused of crimes. The ones who are credibly accused of crimes, you prosecute them in a fair process, which could include plea bargains, credit for time served, effectively ending their detention, most likely. And you can't extract the existence of detention at Guantanamo from the notion of ill treatment and from the legal problems, because you need to recall that Guantanamo was created precisely because the US government believed it would be outside of the law. And that's not because it was going to be a country club. It was meant to be outside of the law for a reason, because of the things that were happening, because it was illegal, because the public shouldn't know the terrible things that were being done there. That didn't work entirely effectively. Over time, judges did stand up, and lawyers did, of course, although that took a little while, and then judges, but it's not as if anyone has ordered it closed or ordered the release of very many people. So we have a 20-year history here of something that the US has done that is fundamentally illegal under international law, arguably illegal under US law, and has set a really damaging precedent for what other countries can do around the world. Now, I could spend hours talking about what is wrong with the experience of Guantanamo now for the men who are there and the ones who were there. But I just want to pause for a moment and highlight what it means to the rest of the world that Guantanamo remains open. Human Rights Watch documents human rights violations in 90 countries around the world. And I have story after story from colleagues who will say, you know, I spoke to General X about so-and-so or this government official about this in my country. And they said, oh yeah, look at the US, look at Guantanamo, look at what they're doing. Time and time again, people who violate human rights point to the US violation to help defend their own crimes. Now that doesn't justify their crimes, but it does make it politically very difficult for the United States to influence other countries. The US has instead set a dangerous precedent, which it tries to indicate is a sort of aberration, but 20 years is not an aberration. Certainly, like I said, for law students today, you know, if 20 years is basically their lives since kindergarten or before, that's not an aberration. So it's really essential, not only for the people who are currently detained in Guantanamo, that it be closed quickly, immediately, with appropriate compensation, redress for people who were detained, appropriate treatment, and so on, but that the US break definitively with this post 9/11 notion that the United States could essentially do whatever it wanted outside of the law, and it could do so based on fear. And Guantanamo is really the epitome of fear-based domestic and foreign policy that took hold immediately after 9/11. This administration has attempted to sort of step back from that. And I'm quite hopeful that because the president tied the Afghanistan withdrawal to the 9/11 anniversary, the 20th anniversary will be coming up, that he recognizes this moment to break. But, you know, if Guantanamo's open, the military commissions are proceeding, and everyone who's being detained without charge is still there come the 20th anniversary, it won't mean much. And the political imperative will have shifted. So I really believe the next few months are a very critical moment for this administration and for people who are pressing the administration to be demanding a definitive break from the post 9/11 policies.
Thanks so much, Andrea, for sharing that with us. There has been progress, and I also want to lift up the work of advocacy organizations and activists across the United States who are doing all kinds of work in honor of the 20th anniversary of 9/11. And as part of that, I think it's critical that folks not forget about Guantanamo and continue to push for the base to be, you know, definitively and summarily closed. With that, I want to return to the good doctor, Dr. Porterfield. I was hoping you could talk a little bit about how, apart from individual cases, what does the mistreatment that you've spoken about today mean in terms of what the field of mental and physical health does in terms of prisoners and detained individuals going forward?
Yeah, I mean, like I ended on my previous remark talking about how there's not really therapeutic recourse in Guantanamo for what happened. So these guys are talking about legal recourse, right? And how there's not been a proper recourse available. And in a lot of ways, that's parallel to the physical and mental health of the detainees, which is there has not been appropriate recourse based on what happened to them. Sometimes I say it's kind of like if a doctor was in a prison and he stepped into a cell of an incarcerated person and he looked around and the entire cell was enveloped in asbestos. And the prisoner was complaining of shortness of breath and lung problems and difficulty. And then the doctor just said, okay, and just stepped back out of the cell. In other words, leaving people in the setting in which the toxic cause of many of their problems still remains, and then not asking about that toxic cause, right? I'm not going to point out that your cell's covered in asbestos. What you have is a situation in which a person is not going to get appropriate care then. And what we do know, again, this is not just coming out of Guantanamo, what we know in the field of mental health and torture treatment and trauma treatment is that people's difficulties need to be acknowledged, the things that happen to them. They need physical safety and healing from being traumatized. They need psychological healing, which is through often a narrative or being able to speak and be heard. And then they need social recovery of community. And again, none of that is capable if you're in a place where the torture and maltreatment happened and where essentially medical professionals are not allowed to work with you and explore what happened to you. You can't ask. Now that's a really big problem. And I think that again, internationally around the world, incarceration standards are better than that. You know, they say people get social contacts, they get visits, they get care based on their complaints. They're not in isolation for extended periods of time. So we know what's needed. And so I think you said, you know, what's it mean in terms of the field of mental health and physical health? What it means is we know what to do. You know, it's just not being chosen to be done. So it's not, you know, again, I'll leave to these guys much larger questions around how do we address it and you know, internationally, how do we then recover? But I can just tell you clinically, you can't have someone sitting in their traumatic events and not be able to report it, get evaluated for it, and then get treatment for it. That's going to make people get sicker.
Thank you, and I think it's a really powerful reflection, right? We know from the field and from clinical research what needs to be done, and we have intentionally, deliberately made the choice to not do it. And in doing so, we are not only causing harm to these individual detainees, we are violating clinical standards, of course, but also causing harm to the entire field of sort of, you know, penitentiary control. So absolutely. I want to go ahead and jump to you, Alka. How do you suggest we move forward with these cases, and why?
Well, I think there's no question of forward with the cases. It's really only how far backward from the rule of law the cases drag us, I think. You know, I want to talk about why, you know, Dr. Porterfield outlined like how this affects you, right? Why does the United States withhold medical care? Why do we, you know, sort of do the doctors refuse to take histories of these men? And let me just drill down for a second, because, you know, the short answer to your question, Arjun, is that, you know, as someone who sees the system close up and has worked within it, as has Andrea previously, you know, I don't suggest, and I'll speak just for myself, I don't suggest that we continue. It's not workable. The government could have chosen to prosecute these men fairly after they were captured, bringing them here, regularly constituted courts, without torturing them for years at the black sites to get, you know, intelligence information that was unreliable anyway. That's not the reality that we have now. We did choose that path of torture in the name of intelligence gathering over the carrying out of justice and the legal process. We made that decision almost 20 years ago. And the crux of the problem is this, right? The CIA and the government by extension still prioritizes holding on to information about the torture program and keeping it secret rather than allowing it to be disclosed, rather than releasing that hold, right? Rather than allowing, you know, independent medical professionals to treat these men, which wouldn't be possible anyway. But rather than, you know, they haven't let go of that sort of death grip over this torture information. They don't disclose it to us, to defense counsel, even with our security clearances. We've had almost a decade of pretrial hearings, and I think that those hearings have really illustrated in kind of tragic detail that the government could have either given us the tools, legal framework, and the information that was needed to try these cases fairly, or it could choose to hold on to the secrecy, right? This kind of shameful secrecy. It can't do both, right? It could never do both. And so, you know, I'm sorry to say it, but it's too late now even for that choice. So now, right, on our side, we've got the men themselves who are deteriorating, who are suffering from their lack of treatment. We've got exculpatory evidence that's been lost or deliberately destroyed by the government. We've got witnesses who have died. On the government side, they don't have evidence that isn't the product of torture. The only way this farce continues is by applying kind of one-sided rules in a completely rigged system to allow the government to hold a show trial. And I don't think that's acceptable. I don't think a lot of people think that's acceptable. I participated with a lot of other kind of stakeholders, people from major NGOs, family members of 9/11 victims, in creating a roadmap last fall that has been presented to the Biden administration. And it proposes a few things. First, really quickly on the habeas side, it proposes immediately reopening the office of the special envoy at the State Department. Get the cleared men out. There are 5 men there who are cleared for release, who should have been released years ago, who should not still be there, and we should have a special envoy negotiating for their releases right now. We need to provide resourcing for the review boards, the periodic review boards, so that they can clear others against whom we have never had and never will have charges. Like, we can't hold on to this concept of forever prisoners anymore. It is grotesque amidst all of this highbrow rhetoric of US adherence to human rights, which is this, we've seen a big renewal of the rhetoric, which is, it's welcome, right, after the past 4 years, but you can't just talk about it anymore. It's just not, it's not holding any water. And, you know, the stories that Andrea tells are really important about how much credibility we've lost because of that. On the commission side, right, it's not a coincidence that the men who have faced charges are among the worst who were tortured. The cases should be resolved. This is not an original thought from me, right? We had a convening authority a few years ago who recognized at least some of the futility and the waste of the commissions and tried to resolve the cases and was fired for it. So, you know, the cases need to be resolved and the men need to be transferred to places where they can receive torture treatment. And no matter what our feelings are about that, and I recognize there's strong feelings on all sides, how could there not be, right? There has to be a moment where we stop and we course correct. I think Andrea said we have to have a break, right, with this kind of lawlessness that we've been operating with. And we say, really, this is the only solution that is legally and morally acceptable. Any other course we've tried has been illegal and has damaged our credibility with allies and with opponents, right? So resolve the cases. I don't want the United States to be the primary creator of bad precedent in international criminal law or, you know, the adjudication of the laws of war. And anyone using a long lens on the rule of law should feel the same way, I think. So scrap the commissions, negotiate safe transfers for medical treatments, which has been done for other prominent, you know, suspects or defendants in other cases of international consequence. None of this is you know, brand new, untrodden ground. So that would be my position.
Thanks so much, Alka. We already have our first question. And as a reminder, we do have time at the end. We'll hopefully have at least 10 minutes for questions. So folks should feel free to go ahead and use the chat box. Andrea, your thinking on the way forward is a bit different. How do you envision it and why?
Yeah, I don't think it's fundamentally different. I mean, I think there is, you know, I would love to rest purely on principle. For example, I don't think there should be PRBs because these are people who are being illegally detained, so they should be released immediately. Do I think it's realistic that this administration will just open up the doors? No, I didn't think it was realistic that any of the 4 administrations that have been holding detainees would just open up the doors. And, you know, the moments for those significant actions to take place pass very quickly with every administration. So, you know, the morning when I woke up and read the news that that Obama had announced, or Holder had announced, that the 9/11 detainees would be tried in New York, I knew it was over. The announcement needed to be, this morning they arrived in the Southern District of New York and are being arraigned this morning. And it was all over after that point. So, you know, if on Biden's first day in office, he had announced that Guantanamo was now closed and the team was there transporting people, we would have some real progress, but we don't have that, which means we're going to have a boring, politically face-saving process if we get one at all. So that will likely include more robust PRBs. You know, the question in the chat is about transferring people to federal court, and individual detainee counsel have their own views on that. There are absolutely people who should not be prosecuted, either because there is insufficient evidence for moral and ethical reasons related to their treatment. Do I think the charges against the 9/11 suspects will be dropped? Of course not. But the capital component of the charge might be. A plea arrangement could be made that included continued detention in the US, in another country, elsewhere. There are a lot of options that are available. As Alka said, there are a number of documents that are out there that exist, public and private recommendations to this administration for how to move forward. But the concern that I have is that the way it moves forward should occur in a way that is consistent with what we want to see in the future. So the PRBs are an example for me. I don't want to validate the fact that people who are detained illegally in violation of international law should have to go through a process that says whether or not they continue to pose a threat. And that's what the PRB is right now. But if I were representing a detainee who was trying to get home, I would fight to have the most robust PRB where I could present, the best evidence and get him out of there. So that's why I think it's helpful to have people talk about this from really different perspectives, and hopefully with different ideas, we'll come to some kind of resolution. But I said hopefully. I'm actually, I have to be honest, I'm not very hopeful that Guantanamo will be closed anytime soon. I don't see the kind of political momentum that we would need to see for any real progress. I can imagine the population dwindling, but then what? We're still in the same place. And it surprises me that this administration doesn't recognize, maybe in part because Trump never did it, right? He threatened to put more people in Guantanamo, but never did. So I think the political threat of permanently institutionalizing Guantanamo doesn't sort of stare this administration in the face, but it should, because 20 years is a really long time. And if it's 21 years, 22 years, 23 years, if it's 4 administrations, it's Democrats and Republicans, it's hard to see what the real momentum would be, other than the facility might actually collapse into the sand if it doesn't get repaired. And once you talk about how much it costs to fix it, maybe that will ultimately be the decision point for Congress.
Thanks so much, Andrea, and thanks for the sobering assessment. I think there are plenty of advocates who have been fighting for 20 years, who have hoped at different points that the base would be closed, and I think I see it similarly. I sort of see the idea of the base being closed. I sort of look at it with skepticism. I hope it is, but I don't know that it's in the cards quite yet. We are running ahead of schedule, which is always wonderful generally, especially in the age of Zoom. What I'd like to do now is I'd like to ask Alka, in this order, Alka, Andrea, and Dr. Porterfield, really to just take a couple of minutes. You've already done this, but just take a couple of minutes to share any final reflections. Maybe there are additional special issues you'd like to address, or something you'd like to respond to that one of the other panelists raised. So we can go in the order of Alka, Andrea, and then Dr. Porterfield, and then we'll open it up to questions.
I think I maybe just want to emphasize what Andrea said about needing to take quicker action, and the fact that this administration has not done so is really very disappointing. And I'll give you an example. Over the past several years, so the sort of what we call the high value detainees, which is really just a euphemism for the men who are held by the CIA, the black sites, have always been held at a camp called Camp 7 at Guantanamo. And it was the most restrictive camp. It was for a very long time, there were conditions akin to solitary confinement there until relatively recently. And that camp, the facility itself was literally falling apart. There were cracks in the foundation. There was sewage seeping into cells. Things didn't work. Locks weren't working. Just really, really dire conditions. And, as we thought over the past year or two, as all of us detainee counsel, NGOs, and medical professionals, as we all thought about how do we close Guantanamo, this was a big issue. That look, the camp is literally falling apart. We want Guantanamo closed. Close the camp. transfer the guys, right? Like, let's start getting people out of this situation. And so what actually happened was, you know, we've sort of made some noise about this. There's been former camp commanders who talked about this in the press, from Camp 7. And so a few weeks ago, over the weekend, we get a call from the media, right? Detainee Counsel, we get a call from the media saying, hey, just FYI, they moved all your guys to Camp 5, which has been empty for a few years since the population cut down, right? Nobody gave us a heads up, right? They just move all these torture victims overnight to Camp 5. Now, Camp 5 has its own issues, and we're going to be talking in great detail in public with the media and with a whole lot of other people about like what the conditions of confinement are at Camp 5 and why they're not acceptable either. But it just seemed like such a delay tactic, right? Instead of actually, again, reappointing the special envoy, moving people out, taking actual concrete steps to close the place, which they keep saying publicly they want to do, right? As recently as a day and a half ago, I think the Secretary of State said something on 60 Minutes about how they still want to close Guantanamo. Instead of taking any of the concrete steps they could have taken, they just move one set of guys from one camp to another. And because, again, of all the classification and the difficulty in communications from Guantanamo and all of that, they can do it relatively quietly without a whole lot of people making a whole lot of noise. So that kind of thing to me is disappointing, bordering on duplicitous. It is really, really, it really doesn't give me a lot of hope. And I genuinely do hope that this administration decides to turn things around and take more decisive action.
Thanks so much, Andrea.
I just want to speak briefly on the role of lawyers, because the ABA, as many of you know, has really been a tremendous supporter and leader in a number of areas in terms of pressing for fair process. At Guantanamo, I see Neil Sonnet is participating and, you know, for many years really led on this. So I want to thank the ABA for that, and also ask everyone listening, you know, as the legal community, to think about the role of lawyers in this nearly 20-year project. And that occurs at every level. There are lawyers, as we all know, there were lawyers who wrote the justifications for torture. There are lawyers who gave comfort to the torturers. There are lawyers who have written and rewritten the authorizations for use of force, the legal interpretations of the authorizations for use of force. And obviously there are lawyers who continue to defend the detention and prosecute these cases. And then there are, of course, the many, many lawyers who have fought against the detention and defend the detainees. The legal community has, I think, a really important and powerful role. And under the Obama administration, everyone liked to talk about how Obama was a constitutional law professor, sort of. And, you know, that law mattered. It didn't. I don't know that that means that it will matter more to this administration, but I do think that just as I hope the administration uses the upcoming 9/11 anniversary as a pivot point or a breaking point, that the legal community reflect itself on the role that lawyers have played in the last 20 years and think about what they would like the legal landscape to look like in the future.
Thank you. Final word, Dr. Porterfield?
Yeah, I think I'll just piggyback off that and say, you know, and that the medical and mental health community recognizes that an astonishing thing has happened, which is that our country has admitted that they tortured a lot of people. And in fact, you know, we have a president who used that word, right, who said we tortured some folks. And so our community needs to think about, is that, you know, what does that mean about how we then speak about and move towards trauma-informed care, you know, for people that this happened to. So I guess for me, it's like, you know, Professor Sethi said at the beginning, like part of why you arranged this was like keep Guantanamo as a topic. And I think that language is really interesting. Keeping it as a topic suggests you're trying to make sure it doesn't disappear as a topic. And I think for the people who were, you know, physically harmed and psychologically harmed, keeping it as a topic in our field would mean continuing to think about their needs and find ways to address them truly and holistically.
I want to thank all three of the panelists for being here. for sharing their insights, yeah, for having this important discussion. It is a sad reality that Guantanamo often goes ignored, is often neglected. And I think it is important to continue to talk about it. And thank you to each of you for your work. It has been a long 20 years. Thank you to the ABA for their leadership on this as well. The questions are coming in, and so let's go ahead and jump right in. The first question is from Claire. I'll go ahead and read it out loud, and any of the panelists are welcome to answer it. If the Biden administration were willing, would there be a realistic path now to bring the remaining defendants into federal court and shut down the commissions? And which defendants or how many would be worthwhile to actually try in court? This had kind of come up before, but I want to go ahead and sort of raise the question.
Andrea, do you want to go first?
Sure. Well, I can speak more generally. Obviously, each detainee is going to be different, but it is my understanding that pretty much every person who has been charged is open to some kind of resolution. So if the Biden administration seriously wanted to make this happen, I think that they could. I don't know what that would look like, but I think that there are a lot of creative ideas out there. For example, could charges be implemented first, pleas taken by video, and then people physically transported? That would resolve the congressional barrier on transfer. You know, there are all sorts of different creative ways of making it happen, but you have to have a really motivated administration with a clear direction to the Department of Justice about how things should look.
Yeah, I guess the only thing I would add is that, you know, I represent one particular detainee at the moment, and every detainee has their own attorneys, and each legal team has their own position on what they would want to do in this situation. I think Andrea is right that that everyone is open to discussions about resolution. The question, though, I think is about whether we're still going to try people, whether we're going to put people on trial. And, you know, as I said, and this is speaking solely from, you know, on behalf of my client and from my perspective, I don't think that's possible anymore unless you're willing to go down the path of a show trial. It's just, we're 20 years out. We don't have, you know, the government doesn't have the evidence. We don't have the evidence. I don't think it's worth further compromising our justice system by bringing these cases to trial. And again, that's my opinion.
Thank you both. Our next question is from Alberto Mora. Who is the U.S. government official other than the president directing and responsible for the Guantanamo detention and legal policies?
I think it's safe to say that your guess is as good as ours. It's not a case of not knowing, it's that there isn't a person or a group.
Can I just propose that if anyone from the White House or DOD or state is listening, Alberto Mora would be an amazing person to take responsibility for closing Guantanamo. I just want to put that in the universe.
Thanks so much, and thank you, Alberto, for joining us. Our next question is from Sukhman Dami. Sukhman Dami is an old friend, actually, and is the executive director of an organization called NSOF that's worked with survivors of torture in India. Sukhman's question is, where do efforts stand to hold the perpetrators of these abuses accountable, whether it's torture, prosecutorial misconduct, or judicial misconduct? My screen is moving too fast. Do those efforts make it more difficult to secure the release of those arbitrarily detained? Anyone's open to sort of answer that. And I want to really kind of echo the point that Andrea made earlier about there are so many lawyers in particular who have enabled and participated in these atrocities. And so when we're thinking about accountability, you know, lawyers are some of the first people that do come to mind. Does anyone want to take on Sukhman's question?
So, yeah, I guess 2 points. The first is that the efforts are going exactly nowhere and have been going nowhere for a very long time. You know, there were a number of cases brought over the first sort of decade after the CIA program began, and they were thrown out of federal court on the basis, and I'm really summarizing here just because of time, but they were thrown out of court on the basis of the state secrets privilege. The SSCI report was one step forward, but the full report remains classified. And there are a whole bunch of us who have been asking for declassification of that report because the public deserves to know the details of what happened, and really only a very small percentage of what happened is still known publicly. The one point though, well, actually, because I think this actually relates to one of the questions I saw later from Rick Kamen, who it's delightful to have on here, which relates to the government cert position in the Abu Zubaydah case. And for anybody who's not familiar with that, Abu Zubaydah has, again, and I'm going to summarize, has his legal team has fought for a while to get access to the CIA contractors, Doctors Mitchell and Jessen, who are commonly known as the architects of the CIA torture program, and be able to get their testimony in federal court. I think it was the Ninth Circuit that actually ruled in, the government invoked the state secrets privilege. The Ninth Circuit ruled in favor of Abu Zubaydah, which was quite a big step. And then the government filed a petition for certiorari in front of before the Supreme Court, which was accepted last week or the week before, I think. So that's going to be heard by the Supreme Court. I'm not confident that it's going to be resolved in favor of Abu Zubaydah at the Supreme Court. But I think the government's cert petition is sort of ground that we've tried before. It's the government trying to invoke the state secrets privilege over information that primarily does not affect national security. And we know that because we just had Mitchell and Jessen testify in public at the military commission at Guantanamo Bay. So, I think the government's position here, and it is really, again, maybe not surprising, but disappointing that the Biden administration took the same position that the Trump administration did on this, which is that, yes, we need to continue to invoke the state secrets privilege, and we are the only arbiters of whether the state secrets privilege is being invoked rightfully. But I think they're on really shaky ground here legally and factually. So I guess we'll see what happens. But that it ties into the government writ large, administration after administration, seeking to block any accountability for the abuse that took place. And the one other really short point I want to make, and I'm sorry I've been talking for so long, but the really short point I want to make, and really maybe throw it to Dr. Porterfield, is having mentioned Mitchell and Jessen, it's not just lawyers, right, who are, responsible for a lot of these abuses. There were a lot of doctors and psychologists who participated in the torture. And there really hasn't been any accountability for that either.
I'll just jump and just say, that accountability usually just does have to have facts, right? And so, you can't have an investigation and an evaluation of abuse that took place if you're not allowed to ask people the questions and pull up the evidence and measure the impact. And again, in social sciences like psychology, we measure the impact with some testing and some interviewing, and doctors measure with other tools. But that's how accountability comes from understanding, well, what happened and what was the impact. And if you can't even do those two steps, you're not going to be able to then say, well, what should we do now to deal with it? So again, I just pull back into my clinical lens and say, accountability is impossible if people aren't allowed to tell their stories and have their stories evaluated and brought out into the domain of, discussing and making some decisions. So it goes back to that cell full of asbestos and the doctor walks in and just backs out and never measures the darn thing.
Thanks so much, Alka. Thanks so much, Dr. Porterfield. Did anyone else want to respond specifically to Rick Kamen's question regarding the government cert petition and Zubaydah? And Rick, it's great to have you on. The last webinar, this committee organized, featured Rick and Carol Rosenberg, and really some extraordinary advocates. So thank you so much for joining for the question. Does anyone want to further respond to Sukhmin or Rick? Okay, so there's a question from an anonymous attendee about saying, you know, I hear a lot about the closing down of Guantanamo, but not about logistical recommendations to ensure that all interests are adequately addressed. What logistical solutions do you propose to ensure that due process rights are addressed while ensuring the government's interests, including national security, are protected through this process? Is anyone interested in tackling that?
I'm happy to jump in. You know, I think this is where the length of time also becomes relevant, because part of what I think brings people to have that kind of conversation is because we exist in a world where we've been having and hearing those conversations for nearly 20 years. If someone were to say to you, you know, should we rape this child because the government has an interest in torturing the parent to get information, we would be outraged, right? But it's only because we have gotten used to the fact that it was okay that these people were raped, were beaten, were waterboarded, some were murdered by the United States government. And then others were detained indefinitely, and we have accepted an alternative legal system, that we can even have these conversations as if all of that came from some legitimate place. And talking about, you know, the fog of war and the fear people experienced post 9/11 that led them to make these decisions. You know, I think that's important when it comes to individual human understanding of why some individual might make a choice. But when you are talking about government policies that were created and have been perpetuated for 2 decades, I just don't think that's a conversation that we can have. The question is not what are the national security interests in illegally detaining and torturing people. There aren't any. And in fact, there are basically zero national security interests, even if someone did have some relevant information. You know, these people don't. And that's been proven time and time again. But I feel like we have been pushed into this trap of accepting that kind of conversation because the American public and the global public were fed a pack of lies for years and years and years by successive governments, that there were incredibly dangerous people who, you know, tens of thousands of ISIS members roam the Middle East. And that doesn't seem to concern anyone, but there are 3 dozen old men with health problems sitting in Cuba, and that terrifies people still. And that is about narrative and information and misinformation, and that is not about security, and it is not about law.
Thanks, Andrea. Our final question is, or maybe there's 2 more. So 2 questions. I'll just sort of ask them both at once so we can wrap up on time. There's a question about a revisiting of the Nuremberg laws. And then there's another question specifically about how corporations in the private sector are tied into the apparatus of Guantanamo. Anyone want to jump in and tackle either question?
I was just wondering for clarity, what revisiting the Nuremberg laws, meaning what exactly?
It looks like that's from Jen Gary. If Jen wants to clarify that, if they're still with us, feel free to do that.
Are we talking about the creation of the separate laws, the anti-Semitic laws? But yeah, I mean, if we get.
I'm not sure. I only have as much detail as you all have. It looks like Jen's still with us, so maybe Jen will clarify in the chat. Oh, it is not enough to say.
I'm not sure about that. As for the private sector, you know, I'm sure that Alka may have some thoughts. You know, in general, unlike in other areas, the private sector involvement has not been significant. I mean, certainly companies take contracts and they build the facility and they rebuild it and so on. That's separate from sort of the contractor issue, if that's what the person was referring to. I mean, certainly early on there were private contractors who were involved in interrogation. And obviously there's a sort of corporate liability issue, but they're just government agents at that point. It's true that their paychecks might have come from someone else, but I don't think that they're really seen as anything other than a government agent who maybe was wearing a different uniform or a different outfit that day. But in terms of sort of like a corporate complicity, there aren't any significant issues that I'm aware of.
No, I think I agree with that. I think just from a really macro level, I just want to mention in terms of corporations and private actors, we can stop, large, we can stop Hollywood from continually showing the torture of brown men as entertaining and effective. Stop doing it. It's not pretty. It doesn't look good and it doesn't work. I mean, if you want to talk about corporate influence, that's partially, it's this nasty cycle, right? Like where we have evidence and memoranda coming from Guantanamo at the very beginning of its lifespan that shows that people who, service members who watched 24 got their ideas about how to treat these men from that, not from, and I know we've just talked about the responsibility of lawyers, and certainly lawyers bear a great deal of responsibility for authorizing things like that. But a lot of this, this sort of ridiculous treatment came from those sort of depictions of like, hey, this works, let's try this. Stop doing it. So that's that. I see that Jen's added a little bit about the following orders.
I think maybe the question was about accountability. So just to clarify, there is no defense that someone was following orders. That's not a defense. On the contrary, there is superior liability in addition to the liability of the individuals. So you can get the commanding officers. It's been a political defense. And just one issue on accountability we hadn't mentioned yet is the ICC, the International Criminal Court, where the Afghanistan investigation incorporates mistreatment that occurred by US government employees in Afghanistan, which should include a CIA black site as well as the military abuse there. And the US, of course, strenuously objects to that jurisdiction on principle and by claiming that there have been adequate attempts at accountability in the US. So feel free to go to hrw.org and read all about why we don't agree with that. Virtually, there have been some prosecutions of people for detainee abuse, only at a very low level. Almost no one has been held to account. No one senior has been held to account, and no one who has authorized any of the conduct has been held to account. We've put out multiple reports actually documenting the case for criminal investigations into senior government officials as high up as then or former President Bush. Again, feel free to take a look on our website, but none of that has happened. If the US has its way, the ICC investigation will not proceed. I'm not going to predict about that, but it is a very live issue right now before the ICC. And some of you may be aware, the American Society of International Law just released a report a few days ago with some recommendations for how the US should be engaging with the ICC, including touching on the issue of the Afghanistan investigation.
Well, thank you. We're a few minutes over, but this was a really great conversation. Thank you to all the attendees for taking the time out of your busy day to join us. Thank you to the ABA. Special thanks to Patrice Payne, who behind the scenes is so helpful with scheduling, helping us get organized, introducing the conversation, always just being a wonderful source of support for all of us at the ABA and the criminal justice section. Thank you, Patrice.
Thank you. On behalf of this section, we want to thank our panelists for taking the time to share their expertise, and a huge thank you to our audience as well.
Yeah, and thank you absolutely to Alka, Andrea, and Dr. Porterfield. Really thoughtful conversation. Thank you for all your advocacy. Thank you for being outspoken on this issue for so long. And we hope to see you all soon.
Thank you.
Thanks, Arjun.
Take care, everybody. Be safe.
You too.